all ready? Yeah. All right.
One more second.
Dance for the camera.
That's always awkward.
Alright,
Okay.
Contention 1 is inherency, and USB Morrison, the court ignored congressional findings linking domestic violence to commerce, stripping the nation of a national civil rights remedy for domestic violence, ACLU in 06. The Rollback and Civil Rights Protection has specific ramifications. USC Morrison ordered for civil remedies for victims of domestic violence. The court noted that violence against women is a local, not national issue. Therefore, matter for state law, there is now no federal judicial remedy compensating women for violence by private actors. Few states have specific anti-discrimination provisions protecting domestic violence victims. Instead, there are piecemeal protection, often without a private enforcement option. Thus, without uniform federal legislation, many victims remain unprotected. Contention 2 is violence to advantage. 1 is domestic violence. Initially, note that every year 2,000 to 4,000 women die from domestic abuse in America alone, and 75% of women will be the victims of some form of abuse. Following in 2000, across the country, 2,000 to 4,000 women die from abuse for domestic abuse. Violence against women in America days are shocking proportions that violent text by my not top list of just American women's health. Yeah, 4 women will be victims of at least one violent crime during lifetime. The same impact violent crime in a woman is clear. 50% of rape victims lose their jobs or are forced to quit because of the crime severity. The statistics should make us a nation pause to consider not only what's going on, but what can be done to correct it. The court's decision Morrison strict on one of the most important provisions in legislation of civil rights remedy has been termed a powerful legal sword and perhaps the most significant legislative development for women at the federal level since Title VII. And domestic violence affects all women, relegating women to a life of fear. Coleman in 93, women throughout our country are being beaten, brutalized, and terrorized. Even those women who have been touched by violent crime are being affected. How many women can walk home at night without some thought of what is the safest trap to take or flee? All women are victims of fear, and the fear is generated by the pervasiveness of violence directed against women. Additionally, note that males are victims of domestic violence every 38 seconds. At the end of the round, another 135 men will become victims. Meanwhile, in 05, male victims of domestic violence constitute an increasingly significant proportion of reported domestic violence cases. Men constitute to be accused of domestic violence, extremely disproportionate rate, and male victims are virtually ignored by the judicial system, but focusing only on the violence against women, ignoring the growing number of male victims. Likelihood of domestic violence overall has escalated. About 35,000 men are victims of violence by intimidation, which translates to better male every 37.8 seconds in the United States. Additionally, the civil remedy was necessary to empower victims by ending local inaction, making domestic violence a civil rights issue. Russell in 03, it's part of our Congress sanctioned provision titled Civil Rights Remedy. The remedy gave victims general violence sources to federal court. The remedy wanted to place violence against women in the context of federal civil rights law. States treated violence against women as a private matter, and therefore not appropriate role for legal intervention by enacting remedy. Feminists attempt to recategorize violence against women, but designers of the remedy characterized as a rape and domestic violence and civil rights violation of the private violence to show that general violence affects women as a class by placing the matter in federal courts rather than state courts where the violence often ignored should be less supporters of the remedy. Send a message that violence against women is a matter of public and national concern and federal civil rights. They issued the provision placed power in the hands of victims rather than that of prosecutors, and sexual violence is a form of social control where the perpetrator dooms the victim to social death. Gordon in 2000. Sexual violence is a gender phenomenon that's nature recovery reflecting pre-existing social economic disparities. The relationship between victim and perpetrator reflecting existing power differentials, struggle between people. Sexual violence means gender inequality, so it reflects other forms of social inequality. Sexual violence correlates socially with specific social setting and circumstance situations which relations are hierarchically structured in terms of dominance and submission. Survivors may experience physical injury, sexually extreme infection. The physical consequence may be easier to relate than psychological and emotional or spiritual damage which may be devastating. The consequence of sexual victimization may be disastrous, include rejection, social death, and further violence. Also, we have an obligation to stop violence against women. It robs them of the rights of life. Amnesty International and 06, violence against women is the global pandemic. Domestic violence violation of women's rights to physical integrity, to liberty, and her rights to life itself. And states fail to do basic steps needed to protect women from domestic violence. States are failing in their obligation to protect women from torture. Moreover, torture is the ultimate form of dehumanization. Scary in 85, torture is required to make visible the connection between pain and death, both as radical and absolute pain is the equivalent of felt experience of what is unfeelable and death. The content of consciousness are destroyed. The two are the most intense forms of negation. The purest expression of anti-human annihilation. Physical pain always violence, death, and the infliction of physical pain is always mock execution. The systemic violence against women creates a regime of political domination tantamount to interstate war. Rape in 97, no matter where a woman lives, she is grave risk of being beaten, religious slavery, prostituted, physically tortured, murdered simply because she is a woman. Peace does not describe her existence. Her definition of war and peace should be questioned to describe the condition of peace is to not affect sexual terrorism on all women because we're socially, I think, times wars and the groups of men fighting over physical territory. We do not consider the possibility of war outside the snare scope. Sexual victimization communicates most of dominance and ownership over women. We would be able to conceive the notion of war at any time one group uses violence to subordinate another group. The group would be perpetuating war. Advantage 2 is identity hierarchies. The civil rights remedy was necessary to shatter binaries by describing gender violence and sexual discrimination against gender identity. McKinnon in 2000, the civil rights remedy placed violence against women in the law of sex discrimination, recognized the violence against women's gender-based violence in first legislation anywhere to recognize there would be an active sex inequality, looking at gender-based violence under the rubric of civil rights for survivors from an contextualized the stigma standard. Vowel placed state power directly in the hands of those victimized. Section 1391 introduced written accountable survivors by empowering rather than pitting individuals with sex-based violence, civil remedy allows survivors to initiate control of their own litigation, while civil remedy offers injunctive relief from damages, levers resources, and finding solitary perpetrators' behavior and value, and restore survivors. Next, Morrison was a grave defeat for domestic violence victims. The courts will only go home, go back to the private realm where they would be further abused. McKinnon in 2000, Morrison will went back home to the violent is constitutional message about a woman's only states can take equality rights away, and only states can impunity. Morrison court for sex equality, reduce women claiming the most basic right of citizenship and standing even Euro and Shake here again. Morrison closed a crucial avenue of access to equality and Rwanda, able to devastating blows of involvement of women's human rights against sex-based violence and her grounds zero for citizenship and social security and women's human status, sexual inviolability is staples something less than whether women are full citizens and full human beings equals a plus power to female sovereignty in women's hands. And binaries are the cause of oppressive identity hierarchies. Runner in 2006 under deconstruction assessed its final binary aspect of such gender and identity binary labels oversimplified complex identity compilation appreciating understandable identity hierarchies. One can dispense with identity, so one can dispense with oppressive identity hierarchies and attaching characters to number sex invoking labels and reattaching the number of sex invoking labels. There's potential list of theoretical frameworks to go step further and dismantle the entire gender hierarchy. Also, heterosexism is the binary we must deconstruct before we can successfully interrogate other hierarchies. Peterson in 99. Even though the empirical marker of oppression is not that of sex difference, the naturalization of that oppression is strictly tied from the heterosexist ideology and integration of the feminine critique is imperative for deconstructing this naturalization of the intergroup conflict. This foundational binary is relevant and correctional hierarchical difference in the context of systemic violence, heterosexism, maybe the historically constructed difference we most need to see and most need to deconstruct. And the hierarchies of domination create autonomous economies which produce warnings that threaten our survival. Scenes in 98. Not only is war part of women's daily existence, but war violence and women's all oppression all grow from the same root and inseparable from patriarchy. The associated power with masculinity which starts to be a community. True by conquest, domination, opposition, man and woman is an opposition resting on equal threats existence. The raise question how we can understand not only the patriarchal state, but also struggle with an internal hierarchy. Human survival may depend upon breaking the linkage to masculinity, and that's to redefine and confront the barriers of community directly with this fear of the feminine. Finally, when the absence of words presented the condition for peace, systemic violence becomes invisible and hence inevitable. Only by engaging in a process of promoting a positive peace for life that is placed in the margins can we undo violence. American Chronicle in 06. Negative peace of the absence, war, positive peace is more complicated to be the struggle for social justice, integration of cultural media violence, violence, war, positive peace, and science violence, so much wider scope and equality, fall under positive peace definition of violence, the dominant interpretation peace, negative peace is comfortable excuse for the privilege to ignore the world the warrior ages every day around accessibility to one of the less fortunate people die from causes you can't even begin to imagine. So when you drop an issue, we update our tactical, logistical, nuclear launch capabilities. Why do this? We're a peaceful, logical thing to do, to military hard risk, you cannot see a fight the next war. If we were adopted to be a peace of process rather than much display disregard for the sanctity of all that could be alleviated, we think of peace as a process requiring continual work, but never fully achievable. That repeating word allows to recognize these deaths true violence that will connect with individuals who lose their lives like so many lives will finally be at peace. How's the plan? The United States Supreme Court should affirm a federal civil rights remedy for domestic violence by overruling U.S. v. Morrison 529 U.S. 598 decision on holding that gendered violence has a substantial effect on interstate commerce. Contention 3, solvency. Initially, note that using the Commerce Clause to end domestic violence sends a strong signal of respect for domestic violence victims. McKinnon in 2000, the Court's economic essentialism devalued women's material activity and raised the documented financial losses by women's violations and notion of servitude, specifically the magistrate correctional findings evidence in the package gender-based violence and women's economic opportunity. More simplicity declined to aggregate the documented effects into national impact because they did not see them as economic effects. Moreover, reversing Morrison to symbolize the Court's greater respect for women and the impact of gender-motivated violence on their lives. Benedict in 02, progressively the Constitution of the powerful gender family murdering hierarchies that are originally based on race, class, and gender. The Constitution is open to multiple interpretations, including those capable of facilitating progressive cause and policy disbelief, is the unspoken argument in the Morrison dissent and acceptance of 39 and one would have both concrete and symbolic. In fact, 39 would break down barriers to women's access to federal courts. Acceptance would finally symbolize recognition of gender-based violence as a national problem where the national attention of federal judicial resources, women's participation in public has been inhibited by the perception that women are primarily private actors instead of the removal on politics. Civil rights remedy was an essential step to women's full equality under the law and opening avenues for women's access to the court. Pressure States Act 2 B. Miller in 05, human rights discourse of incorporating activism against gender violence and eliminating violence against women through national systems of federalism and primary objective reform is to improve women's access to courts and legal mechanisms to address violence. This is a positive transformation and is important since sexual violence is no longer treated as domestic and trivial issue, but instead as a matter of public significance. Plus, with civil rights remedies empowers victims to transform societal attitudes about domestic and sexual violence, including officials charged with responding to such violence. Gold Farm in 03, civil rights claims are intrinsically assertive and constituted man to be heard against constitutional individually and as a group. They also the capacity to society as a whole by transforming a culture of freedom of reference about civil rights provision had the potential to counteract a number of damaging beliefs to the common society. Federal civil rights guarantee historically been a uniquely powerful medium for communicating support for equality, opposition, discrimination, violence provision was capable of altering sex discriminatory attitude and behavior not only of private citizens but also officials charged with the task of responding to such violence. Finally, civil remedies are official supplements to criminal laws. Domestic violence is very difficult to stop, so we need every weapon. Freeman in 03, civil remedies for domestic violence are a nuclear resource for domestic violence victims. Domestic violence rights for harmful, very often it's clean and hard to escape. It will need many times often over a period of years to get them to stop alteration of power dynamics. The domestic violence laws intentionally include civil remedies to remove victim safety on an emergency long-term basis.
Mark this. I didn't read that last line of the last card. That's not
What is the public-private distinction?
I'm not sure where you're getting that question from.
Okay, I guess explain to me these binaries that you're talking about.
Our argument that there's a binary based on gender versus race, whereas we consider acts of sexual terrorism to be something that is dependent on sex.
Binary gender versus race.
On your biological sex versus your gender and your gendered identity. Our argument is that traps us into a binary mode of thought where it's biological men versus biological women. Our McKinnon evidence talks about VAWA being gender-based as opposed to being based on biological sex.
Okay.
And
Where
that's
is the solvency card for it?
It's the first McKinnon card where you're doing that advantage.
Well, I understand how that one says that it's based on gender and not based on
Right,
sex.
right.
Where is the solvency card that says making that distinction breaks down that barrier?
We have a render card, I think it's the third card, and it talks about that specific distinction in regards to all identity hierarchies.
I mean, that says, the process of postmodern deconstruction.
Right, but
I mean, that's not talking about
our argument is that in the status quo we continue to apply sex-based labels to acts of violence. When we stop applying sex-based standards to acts of violence.
So your argument is that when VAWA passes, people will no longer view things in terms of gender, male, female, biological binaries instead. Why didn't that happen the first time it was passed?
It was passed for less than a year. It didn't even exist for that long, and that doesn't give a lot of time for people.
It was passed for less than. What do you mean it was passed for less than?
I mean, VAWA existed. The actual remedy itself did not exist very long. I don't think that really gave time for people outside of women who would probably be on the priority list to go and file for civil remedies in the courts. Because this wouldn't be a matter of just women going to the courts.
Okay,
it's a matter
did
of
any
transsexuals, etc.
All right, that's fine. And is that backed up by any evidence, or that's just what?
That's an assertion, but I think it's a pretty normal assertion considering that societal transformation doesn't happen overnight. It's a process.
Well, sure, but you have no evidence that people even use, that anyone other than women even tried to use this.
We didn't read any evidence either way on that question.
That's fine.
But people other than women have the capacity to use civil remedies.
Okay.
That's how it's designed.
What is the mechanism for this mindset change?
Our argument is that the court's symbolic, the court's stance when it comes to domestic violence resonates very strongly with the public when it comes to how they perceive domestic violence.
Which card is that?
I think it's...
I mean, your argument is your argument that the abusers will no longer abuse?
Both, right, both the abusers and society at large, not necessarily just the people who are committing the crimes, although our evidence does speak to those people, but also people in the legal sphere who are charged with, going into the court, the police officers that need to deal with domestic violence cases to begin with, as well as the judges, jury, society in general that focuses on domestic violence.
It's